course, there's the legal side of it. And as far as legal documents are concerned, these are things that we should all have. So make a note of this actually, or put a star or an asterisk. It's on page 4 of the handout. These are documents everyone should have regardless of age. Your kids should have them, you should have them, your parents should have them. What are we talking about here? Well, 2 different types of powers of attorney. First of all, a financial power of attorney, as well as a medical power of attorney. That's sometimes referred to as an advanced healthcare directive. As well as a will or a trust. You should have one or the other, and I will talk about that, and we had a question about that earlier. Okay, so financial power of attorney. This is one of the documents referring to the earlier question. This is one of the documents that it's good to have drawn up in Virginia, not in another state. There are specific references to the Virginia Code that we need to make, as well as the Medicaid planning language. If we need to do the gifting, the transferring between the spouses later on, if the spouses are no longer competent to make those transfers, then we want the agent, the son or the daughter, we want your agent to be able to do that for you. Same with real estate, taxes, Social Security. The IRS won't talk to you unless there's a specific provision in the power of attorney giving the agent permission to talk to the IRS. So very important there. You know, often I get the question, you know, this is a page or 2, I just pulled this off the internet, this is fine, right? Well, probably not. You know, the couple of $100 that you'd spend with a lawyer drafting this properly can save you thousands, literally thousands of dollars later on. And I can give you, you know, specific examples of clients where that's happened to them because the power of attorney wasn't Virginia specific or didn't go into enough detail in the right area. And the alternative to that is either guardianship or conservatorship, where you have to go to court, have a conservator appointed, spend untold thousands of dollars for the judge to appoint someone because you're no longer competent to do that yourself. A couple of $100 here, as I say, is money very well spent versus that alternative. The healthcare power, the advanced medical directive, 2 different parts to that. There's the living will. Anyone remember the Terri Schiavo situation? You remember that? That's what the living will says, is, you know, what do I want to do if I'm on a life support machine? How does that work? When would I want to be on it? When would I not want to be on it? And then the medical power of attorney itself, who do you want to make those decisions? A spouse or a child, another family member, to make those decisions for you if you're not able to do that yourself. Very, very important, the living will. And it's important that you have that in writing and you have that conversation with your family ahead of time so they know how you feel about that. You know, it's not a surprise. You're not trying to decide, you know, in the hospital room, not trying to make those decisions. Also, the HIPAA directive. What's HIPAA? You're all familiar when we go into a hospital or a doctor's office, they have you sign that release form. That's HIPAA. What this HIPAA is this is for your family. Because if a family member is making medical decisions for you, obviously they need access to your medical records to make those decisions. You can't do that without the HIPAA release in place. So that's what HIPAA's all about. Okay, so wills versus trusts. Could talk about this all day, but let me just give you very briefly the difference between a will and a trust. Hershey's Kiss here. Does a will have to be probated? Yes? Anyone think no?
Well, it depends on the state, if it's out of state.
Well, yes is the right answer. For the most part, a will has to be probated unless all your assets are joint, so everything's just, husband and wife, one passes to the other. Or unless everything is, for example, in an IRA where, the IRA designates who it goes to. But when yes, sir?
I got to ask the question there. What do you mean by probate?
Probate, okay. Good question. Well, what probate means is if you have a will, it has to be probated. That means you have to have an executor. In Virginia, the executor has to be a Virginia resident. They go down to court, file the will with the court, pay fees, and then they have to file accountings. The executor has to file an initial accounting, 2 interim accountings, a final accounting. That whole process can take 6-9 months easily. It can take a year or more. It's expensive. Oftentimes there's lawyers involved, and of course, as you know, if there's lawyers involved, then that means more money. If the beneficiaries are fighting, then that year can be 18 months or 2 years. A trust avoids all that. So the trust, just in probate fees, the trust can easily pay for itself. But very important to bear in